chamber sentenced Mr. Stanisic and Mr. Simatovic each to 12 years of imprisonment. Mr. Stanisic advances 8 grounds of appeals, and Mr. Simatovic advances 4 grounds of appeal, both challenging their convictions and sentences. They request that the appeals chamber reverse erroneous findings of the trial chamber, quash their convictions, and acquit them. In the alternative, Mr. Stanisic and Mr. Simatovic seek reductions in their sentences, and Mr. Simatovic alternatively requests that the appeal chambers order a retrial. The prosecution responds that both appeals should be dismissed in their entirety. The prosecution presents 2 grounds of appeal with various subgrounds challenging certain findings or conclusions of the trial chamber, including its acquittal of Mr. Stanisic and Mr. Simatovic of joint criminal enterprise liability. The prosecution requests that the appeal chamber correct the trial chamber's errors and convict Mr. Stanisic and Mr. Simatovic as members of a joint criminal enterprise, or alternatively, find them guilty for aiding and abetting crimes in SAO Krajina, SAO SBW, Doboj, and Sanski Most, in addition to Bosanski Shamats. It requests that Mr. Stanisic and Mr. Simatovic's sentences be increased accordingly. Mr. Stanisic and Mr. Simatovic respond that the prosecution's appeal should be dismissed in its entirety. And I will now summarize the manner in which we will proceed. I would like to remind all the parties that the appeal process is not a trial de novo, and the parties must limit their arguments to alleged errors of law which invalidate the trial judgment or alleged errors of fact which occasion a miscarriage of justice. Throughout the hearing, the parties may present the grounds of appeal in any order they consider suitable. The parties shall present their submissions in a precise, clear, and concise manner, and should also provide precise references to material supporting their oral arguments. The judges, of course, may interrupt the parties at any time to ask questions, or they may ask questions following each party's submissions or at the end of the hearing. The appeals chamber is familiar with the briefs, and I would therefore urge the parties not to repeat them verbatim or to summarize extensively the written arguments. Additionally, please inform the bench if proceedings should go into private session to avoid public disclosure of confidential or protected information. The hearing today and tomorrow will proceed as follows. Today, we shall first hear the submissions in support of Mr. Stanisic's appeal for 1 hour. After a pause then of 20 minutes, we shall hear the submissions in support of Mr. Simatovic's appeal for 1 hour. And then, after a pause of 1 hour and 30 minutes, we shall hear the response of the prosecution for 1 hour and 30 minutes. After a 30-minute break, Mr. Stanisic will have 20 minutes for his reply, followed directly by 20 minutes for Mr. Simatovic's reply. Then, tomorrow, starting at 10 a.m., the prosecution will have 1 hour to present its appeal submissions. After a pause of 15 minutes, Mr. Stanisic will have 45 minutes to respond to the prosecution, and this will be followed by a pause of 1 hour and 30 minutes, after which we will hear Mr. Simatovic's response. Directly following this, we shall hear the prosecution's reply for 20 minutes. And at the conclusion of tomorrow's hearing, Mr. Stanisic will have 10 minutes for an optional personal address, followed by 10 minutes for Mr. Simatovic's optional personal address, should they choose to give one. So now I would like to invite counsel for Mr. Stanisic to present his appeal. And Mr. Jordash, you have 1 hour for this part of the session. It's 10:10, so we can start if you're ready. Thank you.
Thank you very much, Your Honours. And just quickly, thank you very much for allowing me to appear remotely. I apologise for any inconvenience. Your Honours, in the first 40 minutes of the hour allotted to our appeal, I will address Mr. Stanisic's appeal against conviction contained in grounds 1 to 4. In the final 20 minutes, Mr. Holmes will address our appeal against sentence contained in grounds 5 to 12. As for conviction, may I make some preliminary observations? Regrettably, instead of focusing only upon the application of the aiding and abetting mode of liability, we will have to address the prosecution's attempt to redefine aiding and abetting. As is plain throughout the prosecution's response, and as we will discuss tomorrow, throughout their whole appeal of the trial chamber's aiding and abetting rulings, or their challenge to our appeal, the prosecution seeks to circumvent the law of this tribunal. As we will also discuss tomorrow, this is also true of their approach to joint criminal enterprise and their purported application of it to the judge's findings. In each instance, they seek to attribute criminal responsibility in violation of the principle of culpability. If we needed to be reminded, slide 2 reiterates this chamber's and the customary law definition of the actus reus and mens rea of aiding and abetting. Focusing on the critical mental element, as argued in grounds 3 and 4 of our appeal brief, paragraphs 127 to 186, the prosecution has to demonstrate that the trial chamber did not err in law or fact in determining that Stanisic knew that the training and deployment assisted or facilitated the specific Bosanski-Samac crimes, and that he knew of the essential elements of the crimes ultimately committed by the principal perpetrators, including their intent. After nearly 3 decades of work at the ICTY and this mechanism, this ought not to be controversial. As the prosecution are aware, and as we argue throughout grounds 1 to 4, the Chamber's reasoning falls significantly short of this analysis. And this is why the prosecution seeks to reinterpret the law. As slide 3 shows, and you can see this at paragraphs 106 to 107, 116, 119, 132, 141, and 150 of their response to our appeal, and similarly in paragraphs 174, 182, 199 to 200, 209 to 210, and 214 of the appeal brief, the prosecution consistently attempts to jettison the 2 principal elements that constitute the mens rea of aiding and abetting. 1, knowledge of assistance, and 2, knowledge of the elements of the crimes, including the intent of the principal perpetrators. They seek to replace these protective elements with an awareness of the probability standard, namely that the unit members trained and deployed would assist the commission of some crimes. Gone is the requirement for Stanisic to have positive knowledge that his own actions contribute to the specific crime. Gone is the requirement that Stanisic had knowledge of the elements of the specific crimes or the intent of the actual principal perpetrators of those specific crimes. Indeed, according to paragraph 24 of the prosecution's response, they even seek to reinterpret the requirement of knowledge of specific crimes, reinterpreting it to mean awareness of the probability of types of crimes, claiming that this is in line with the appeals chamber's case law. Of course it is not, and the prosecution fails to show otherwise. As we argue in our reply, at paragraph 72 to 76 and 88 to 92, there is no support for this interpretation of the elements. As outlined in a series of cases from 2007, Blagojevic and Djukic appeal judgment, to the 2014 Sinovic et al. Appeal judgment, it needs to be established that the accused had these two knowledge elements, not that he ought to have had or could have had knowledge of the crimes. Your Honours will appreciate that the law of this tribunal is consistent with customary law. These elements are confirmed by jurisprudence from around the world, from the US, Australia, Hong Kong, France, Spain, India, Peru, the UK, Bosnia, and so on and so forth. For instance, in the Australian case of Gianni versus the Crown, 1985, 156 CLR 473, in the High Court of Australia, the court held that, quote, no one may be convicted of aiding, abetting, counselling, or procuring the commission of an offence unless, knowing all the essential facts which made what was done a crime, he intentionally aided, abetted, counselled, or procured the acts of the principal offender. Willful blindness is treated as equivalent to knowledge, but neither negligence nor recklessness is sufficient. It is actual knowledge which is required. This tribunal's definition is no different. As for awareness of probability, despite the prosecution's best endeavours, we do not need to concern ourselves with this in this appeal. Any aspect of probability only arises with respect to the type of crimes that the accused knew would be committed, i.e., the starting and end point remains that it must be established that the accused knew that one or more of the specific crimes charged would be committed. As we note at paragraph 133 of our appeal, probability only arises if, quote, the aider and abettor is not certain which of a number of crimes will ultimately be committed, close quote. However, the Chamber found at paragraph 606 to 607 that, quote, the accused knew that their acts assisted the commission of the crimes of persecution, murder, and forcible displacement, and were aware of the essential elements of the crimes, including the intent of the perpetrators, close quote. That is what this appeal is about, not some recklessness or negligence standard. Regrettably, this same attempt to reinterpret the law will be seen in relation to the prosecution's own joint criminal enterprise appeal, ground 1 at paragraphs 16 to 117. It's worth touching upon that very briefly. These grounds concern allegations that Stanisic used direct perpetrators to further the common criminal purpose. Please see slide 4. As your honours know, the joint criminal enterprise tools test has been settled law since Brzezinski and supported notably by the Krajnik Appeals Chamber. Namely that, quote, where the principal perpetrator is not shown to belong to the joint criminal enterprise, the trier of fact must further establish that the crime can be imputed to at least one member of the joint criminal enterprise, and that this member, when using the principal perpetrator, acted in accordance with the common plan. As shown on the screen from paragraph 4 to 8 of Brzezinski, this must be established beyond reasonable doubt to avoid guilt by association. Fast forward to 2023, 20 years after Stanisic's case began, and read the prosecution's appeal advancing a variety of joint criminal enterprise errors of law and fact, twisting and turning to avoid mentioning procurement or tools. As with Stanisic's conviction for aiding and abetting, the prosecution appreciates that an application of the law, a strict application of the law, would lead inexorably to rejection of their arguments. As argued at paragraphs 8 to 13 of our reply to our appeal, the prosecution attempts to evade the strictures of the law the attempt to evade the strictures of the law began in the notice they provided Stanisic way back in 2003. Instead of particularizing Stanisic's aiding and abetting with any particularity, the prosecution's pleading was limited to a joint criminal enterprise pleading, namely that Stanisic agreed with joint criminal enterprise members and principal perpetrators to commit the specific crimes in Bosanski Samaj in furtherance of the common criminal purpose. Of course, this cannot be compliant pleading for aiding and abetting. Aiding and abetting is a completely different mode of liability and warrants its own specific pleading. Again, apologies, but please see slide 5 for the requirements of pleading any mode of liability. This is trite law. If it is acceptable to plead aiding and abetting through a pleading of joint criminal enterprise, then let's be open about it. There is no pleading for aiding and abetting. It is okay to plead just joint criminal enterprise. Of course, that prejudices the accused, but of course, it's also useful for the prosecution because it enables them to mold their case as the evidence unfolds. Let's take their JCE pleading for a moment as concerns Bosanski Samaj. As outlined in their pretrial brief, paragraph 75, 92 to 93, Stanisic was alleged to have provided training, weaponry, equipment, and financing to the unit, alleged to have deployed the unit to Bosanski Samaj, and alleged to have commanded it throughout the operation. One can only assume, if we are to transplant that joint criminal enterprise pleading into an aiding and abetting case, the prosecution's case at that point was that the entirety of these acts were alleged to have had a substantial effect on the Bosanski Samaj crimes, and that Stanisic knew that his actions in being one of the overarching commanders of the operation and an overarching commander of the principal perpetrators from Bosanski Samaj, as well as training, deploying, and commanding the group of men in Bosanski Samaj, would contribute to the commission of the crimes of persecution, murder, deportation, and inhumane acts that were committed in Bosanski Samaj. So the case was that he knew of the essential elements of these crimes, including the intent of the principal perpetrators of the attack, because he organized and commanded the attack and the crimes. As we argue in ground 2, paragraph 52 to 126 of our appeal, it must be immediately obvious that the vast majority of the acts alleged to establish Stanisic's actus reus were found not proven. As found by the chamber, the accused contribution consisted of training and making these forces available during the takeover and not, quote, in directing them during the operation, close quote. In other words, the prosecution's original substantiality case essentially failed. Instead of being the leader of the criminal conduct, the number one man, he was a bit player. No longer the organizer of the operation, and no longer the commander of the operation. Barely involved at all. And Mr. Holmes will touch upon this, of course, in the sentencing submissions. Yet now the prosecution shifts its position. And this is the advantage of a pleading of aiding and abetting being no different to the pleading of joint criminal enterprise. Instead of the array of acts of assistance pleaded in the joint criminal enterprise pleading, the prosecution shift their focus and make some submissions tantamount to suggesting that their case was always that 2.5 weeks of training and de minimis deployment had a substantial effect on the crimes. Despite Stanisic being reduced to a bit player in the Bosanski Samac operations, apparently his knowledge was precisely that alleged pursuant to the joint criminal enterprise. The advantages of relying on JCE notice in lieu of aiding and abetting is elasticity. The disadvantage, of course, is that it prejudices the accused and fair trial rights. Substantial becomes a flexible notion, and we'll see this tomorrow in grounds 1A, 3B of the prosecution's appeal at paragraphs 88 to 92, where after a similar collapse of the Arkan JCE case, they scrabble for a new aiding and abetting case. Since 2003, it's been alleged that Stanisic's principal contribution to the common criminal purpose was by commanding, organizing, and supplying everything that Arkan and the SDG needed throughout 1991 to 1995. Aiding and abetting was but a one-line mention. Now, however, they fight furiously to demonstrate that the chamber erred by not finding that per diem payments by someone in the Serbian DB to 7 SDG members was a substantial contribution to the crimes of perhaps 300 to 400 men. Substantiality and knowledge are for the prosecution elastic elements, and deliberately so. As substantiality stretches way beyond the bounds of credulity, so too does Stanisic's aiding and abetting knowledge in Bosanski Samac. As for mens rea, hardly any of the prosecution's material facts alleged to give rise to knowledge were found established. Stanisic was not found to be in agreement with the joint criminal enterprise members or local authorities to further the common criminal purpose, and he was not, as I've mentioned, found to be in command of a single man in Bosanski Samac. As we argue in our appeal, the trial chamber appears to have constructed a mens rea never envisaged by the prosecution case. Knowledge was now assumed not from command interaction between the accused and those involved in the Bosanski Samac crimes, but only from a prior pattern of crimes in Croatia and Bosnia, and Stanisic's knowledge of the intent of JCE members writ large. Instead of acknowledging how this was never envisaged in the prosecution case, and as I'll argue shortly and as we argue in our appeal, unsustainable as a matter of law, the prosecution fight furiously to uphold the conviction. Of course, the prosecution's failure to plead and the collapse of their case sowed the seeds of the trial chamber's errors of law and fact. The prosecution's approach is a textbook example of how to use vague pleadings to shift your case. Avoid pinning your material facts to the mast of the charges, and anything is possible. 2 de minimis acts, training and deployment, out of a range of much more significant acts, suddenly become the focus of a conviction, suddenly become categorized as substantial, suddenly become the basis upon which knowledge can or could be inferred. Knowledge based on being the main man responsible for the Bosanski Samac operations and command of direct perpetrators intending these specific crimes during the Bosanski Samac operations, morphing into awareness of probability of crimes may be occurring because uninvolved JCE members and different perpetrators of crimes had previously committed crimes in previous Serb military operations. As outlined in grounds 3 and 4, the trial chamber was duty-bound to conduct a fact-based inquiry of Stanisic's knowledge and not to merely presume it from the vestiges of the prosecution's JCE case and an awareness of probability standard. No trier of fact can properly establish knowledge of assistance to specific crimes and knowledge of the elements of the specific crimes, including the intent of the principal perpetrators, without this inquiry. An inquiry which the trial chamber failed to conduct in every meaningful respect. Why do I emphasize no trier of fact? Well, Your Honours do not have to take our word for it. Every single case at the ICTY and ICTR demonstrates this as an immovable proposition. As can be seen on slide 6, the trial chamber, in its application of the legal requirements of mens rea of aiding and abetting, ought to have considered a variety of factors. These were factors necessary to come to a reasoned and reasonable view of Stanisic's knowledge. The relevant principal perpetrators and their intended actions. The context of the attack, including the existence or lack of planning and preparation of, or agreement to commit the crimes by the principal perpetrators, and the extemporaneous nature of the crimes committed. The temporal and physical proximity, as well as the scale and type of practical assistance. The nature, scope, and extent of the knowledge that the accused purportedly possessed in advance of his assistance, including whether the accused was within the circle of knowledge, whether the accused at the time the assistance was provided may have believed that the crimes were unlikely to occur as a consequence of his assistance, the accused's knowledge, whether it existed at the specific time the assistance was provided, and whether the accused possessed the knowledge at any time of each of the essential elements of the crimes committed. These 7 factors are not new requirements. They're not creative thinking by the Stanisic defense. They are factors that every single ICTY and ICTR tribunal have taken into consideration when assessing the mens rea of an accused in relation to aiding and abetting, either alone or in combination, depending on the facts of the case. There has never been a case at the ICTY or ICTY which has determined aiding and abetting knowledge without relying on one or more of these factors. There has never been a finding of knowledge sufficient for an aiding and abetting conviction at these tribunals based only upon an analysis of the previous conduct of uninvolved JCE members, unrelated direct perpetrators, or previous patterns of crimes. We challenge the prosecution to find one, just one. That is why the prosecution tied themselves into knots to change the definition of aiding and abetting. The strict definition leads in only one direction. It's worthwhile going through these factors to show, if it needs to be shown, why this is the case. We outline some of this argument in ground 3 of our appeal brief at paragraphs 144 to 159 and ground 4 at paragraph 161 to 184. Slide 7. The first factor that the trial chamber ought to have considered is the relevant principal perpetrators and their intended actions upon which the existence of the accused's knowledge was purportedly assessed, close quote. This is important for obvious reasons. how can a trial chamber establish an accused's knowledge of the elements of the crimes and the intent of the perpetrators without examining the principal perpetrators and without making appropriate findings? As we argue at paragraphs 144 to 147 and 175 to 178 of our appeal, had the chamber done this, it would have appreciated that the intent of unrelated perpetrators from previous crimes was of little relevance and even less probative value. The prosecution's attempt at paragraph 147 of their response to conjure up a perpetrator connection claim by the claim that Serb forces under the control of named JC members Milosevic, Karadzic, Plavšić and Krajnic were involved in the Bosanski Samac crimes is easily disproved. The chamber made no such relevant findings. The second factor on slide 8 addresses the obligation on the trial chamber to consider the context of the attack, including the existence or lack of planning and preparation of or agreement to commit the crimes by the principal perpetrators, and the extemporaneous nature of the crimes committed. The prosecution's response to paragraph 116 raises a straw man. We are not arguing for an additional requirement to be added to the legal elements of mens rea for the mens rea of aiding and abetting. Instead, what we're saying, and clearly so, is that the chamber must examine the context, and this invariably, maybe even inevitably, involve an assessment of the accused's knowledge of any planning or preparation of the crimes alleged to have been assisted. This is especially so, as in Stanisić's case, where there is an absence of a prior relationship with or control over the principal perpetrators, or otherwise any physical proximity to the planned crimes. How else can crimes that were extemporaneous be distinguished from those specific crimes that were within the accused's knowledge? See slide 9. If the trained and deployed group had continued to commit crimes into 1993 and 1994 and 1995, when would Stanisić's liability have ended? At the risk of being facetious, if they were still committing crimes in 2023, would Stanisić's knowledge be the same? Of course not. Yet this is effectively the chamber's logic. Because it failed to examine the planning, preparation, or agreement, Stanisić was presumed to know of all the crimes until the end of the Bosanski Samac operation, including crimes committed months later. What circumscribed his knowledge and culpability? Nothing other than what the perpetrators did. Rather than an examination of the context, including the planning and the preparation and what Stanisić knew of it, the chamber's approach merely presumed, on the basis of what happened previously in other locations and what was in the minds of unrelated men, that Stanisić knew of all the crimes that might occur in Bosanski Samac in 1992, at any time after the commencement of the operation. That cannot be right. Which leads to the third and related factor on slide 10. The chamber ought to have considered the temporal and physical proximity, as well as the scale and type of practical assistance when assessing the degree of knowledge the crimes required and what could be inferred about Stanisić's knowledge. In the ICTY case of Popović, the trial chamber's findings highlighted how critical the issues of timing and physical proximity are. The trial chamber found that the mens rea requirements had been satisfied because the accused Borovchanin deployed troops to a forcible transfer operation that was ongoing and that he knew was ongoing. Similarly, in the ICTY Merksic case, the trial chamber found that the accused was, quote, aware that some prisoners had indeed been executed by TO and paramilitary forces the previous day, and of the difficulties experienced by JNA soldiers on the 20th of November 1991 by virtue of the efforts of TO and paramilitary forces to gain access to the prisoners of war. The chamber found that when he ordered the withdrawal of the JNA guards, he knew that this left the TO and paramilitary with unrestrained access to the prisoners, and that by enabling this, he was assisting in the commission of the offences of violence and murder that he was aware would indeed probably follow, close quote. In other words, the accused knew his assistance. He knew it would assist crimes. He knew of the intent of the perpetrators, and all this because he was adjudged to be proximate to the action and the crimes. In Stanisic's case, by contrast, as discussed at paragraphs 144 to 159 of our appeal and paragraph 92 of our reply, Stanisic was nowhere near the scene, was not shown to be in communication with the direct perpetrators. The crimes were not taking place at the time of his assistance. The Bosansky-Samach operations hadn't begun. None of the training or deployment was in any way proximate to the eventual crimes. Indeed, as argued at paragraphs 5 and 32 of the appeal, most of the crimes began only several weeks after, and some indeed the worst, many months later. Moving to slide 11, it is also critical that chambers assess the nature, scope, and extent of the knowledge that the accused purportedly possessed in advance of his assistance, including whether the accused was within the circle of knowledge in relation to the impending crimes, or whether the accused's role and type of participation would have allowed him to have knowledge of the crimes charged. For instance, in the ICTR case of Bagasora, the accused Ensign Yumava was also found to have trained and dispatched militiamen to reinforce local forces involved in an attack. The accused had been, quote, requested to send reinforcements by the interim government and did so with full knowledge of the intended purpose and genocidal nature of the operation, close quote. Slide 12. In Djordjevic, the trial chamber found that the accused, the assistant minister of the Serbian MUP, had knowledge that the crimes charged would probably be committed in Kosovo, since not only did he know of the ongoing crimes when he deployed his troops, but he also maintained control over them, had ongoing command over, and was otherwise related to the local units, and even attended joint command meetings during the critical period of the attacks. As is obvious, the chamber made no similar or relevant findings in convicting Stanisic, and none reasonably arise on the facts. Slide 13. Another important factor that the trial chamber ought to consider for its mens rea evaluation is whether the accused at the time that the assistance was provided may have believed that the crimes were unlikely to occur as a consequence of his assistance. This includes an assessment of whether it cannot be ruled out that another equally reasonable inference exists in relation to the accused's beliefs that his acts were directed towards another goal. We deal with this in our reply at paragraphs 91 to 101. The chamber relied upon 1991 to 1992 Croatian operations, Bejlina and Zvornik 1992 operations, and JCE Intent, which involved Matic, SAO Krajina Police, Arkan and his unit, and JCE members Milosevic, Karadzic, Plavšić, and Krajnik. Let me pause for a moment to posit the following. If Stanisic was aware that any of those JCE members or direct perpetrators were going to be involved in the Bosanski Samac operations, and as we note in paragraphs 97 of our reply, quote, if Stanisic was shown to have known that the Bosanski Samac was in furtherance of the common criminal purpose, close quote, then it could reasonably be said that he'd been put on notice of the risk of some crimes. That would not have fully satisfied the mens rea of aiding and abetting, but it would have been an important factor to consider and to weigh into the mix. But that was not the case. There was not a single JCE member or meaningful perpetrator connection between the pattern events the chamber relied upon and the Bosanski Samac crimes. As outlined in the Stanisic appeal brief, at paragraphs 146, none of the principal perpetrators, principally Simic, Cerny, Debeli, or Lugar, were pivotal to the commission of crimes in Bosanski Samac, were JCE members or involved in the previous pattern evidence or pattern findings. Inconceivably, the chamber drew evidence of Stanisic's knowledge that his actions would contribute to the crimes committed by the principal perpetrators based in Bosanski Samac on his potential or supposed awareness of the acts of other JCE members and other perpetrators involved previously in other places in Croatia and Bosnia. How the trial chamber went from assessing the crimes and perpetrators that were not part of the immediate context of the Bosanski Samac operations or crimes to assessing knowledge that Stanisic had in Bosanski Samac is not clear. Their assessment of Stanisic's mens rea in paragraph 606 and 607 of the judgment failed to identify the principal perpetrators in Bosanski Samac, failed to identify Stanisic's relationship with those principal perpetrators, and failed to establish Stanisic's positive knowledge of any preparation or planning by those principal perpetrators. So surely the opposite inference arises. If different perpetrators were involved in Bosanski Samac than the pattern evidence, if no JCE member was involved in the Bosanski Samac operation, the risk of a mirror set of crimes occurring is significantly less. The chamber appears not to have considered that even as a possibility. Slides 14 and 15, I won't dwell on these just because of time, but the accused knowledge and whether it existed at the specific time the assistance was provided, whether the accused possessed knowledge at the time of each of the essential elements of the crimes committed were also essential factual inquiries which the chamber failed to conduct. If it had, it would have appreciated that once again, no adverse inference could be derived from the examination. So in conclusion, the factors I've just gone through are reflected in all the cases at the ICTY and ICTR. In reality, Stanisic and Simatovic stand as the only accused convicted of aiding and abetting without any finding that actually relates to the specific crimes or the specific intent of the specific direct perpetrators, and based on awareness of risk that in reality was significantly lower than the previous operations that the chamber found were part of the pattern evidence. Stanisic's knowledge, therefore, was presumed on the basis of a foreseeability standard rather than an actual knowledge standard. The Chamber did not discuss how the pattern of previous crimes in Croatia or Bosnia had any real relevance to Stanisic's knowledge of the Bosanski-Samac crimes charge. And the absence of any link in the present case is clear from paragraph 607 of the judgment, where the Chamber notes that, quote, Serb forces systematically committed persecution, murder and forcible displacement against the non-Serb inhabitants of the SAO Krajina and the SAO SPWS, close brackets, and, quote, Serb forces attacked Bejlina and Zvornik, close quote, but failed to assess whether these Serb forces were the same as the forces which attacked Bosanski-Samac. They were not. The Chamber would have been forced to observe, if it had examined this fact, if they had examined the principal perpetrators, that there was not this congruence suggested by their pattern evidence theory. Ultimately, the trial chamber failed to clarify how Stanisic's assumed knowledge of previous attacks fulfilled the knowledge requirement. In doing so, the chamber failed to apply the actual mens rea standard under customary international law, namely knowledge of the specific crimes. Moreover, the chamber failed to consider the possibility that Stanisic may not have known that his acts would contribute to the crimes charged. This was a reversal of the burden of proof by any other name. As argued in the reply at paragraph 95, the possibility that military operations were being conducted for defensive reasons was a distinct possibility. When the dust settled in Bosanski-Samac, quote, of the 208 deaths in Bosanski-Samac in 1992, the majority, 123 out of 208 were Serbs. We note this in paragraph 102 of our appeal and paragraph 55 of our reply. Defense was a legitimate and reasonable inference. And so, in conclusion, before I hand over to Mr. Holmes, the trial chamber abandoned the knowledge standard, which is the customary law standard of aiding and abetting. They adopted a much lower standard of recklessness and probable knowledge. And as we note in paragraph 84 of the reply, the focus became, quote, the awareness of a risk that his acts might assist some unspecified crimes which might occur in Bosanski-Samac, close quote. That is not knowledge, and that is not the customary law definition of aiding and abetting, and that invalidates the judgment. No reasonable trial chamber would have arrived at this conviction. May I now hand over to Mr. Holmes, and thank you.
Your Honours, thank you. I'm going to deal now with Stanisic's appeal against sentence, which we argue at grounds 5 to 8 of our appeal. At the outset, it is worthwhile pausing to sum up where we are in these exceptionally protracted proceedings after a 20-year process. There's one conviction for counts 1 to 5 of aiding and abetting in Bosanski-Samac and a sentence of 12 years. Stanisic was arrested on the 13th of March 2003 and made his initial appearance on the 13th of March 2003 and made his initial appearance on the 13th of June 2003. His first trial started on the 9th of June 2009. His first judgment was on the 30th of May 2013. On the 15th of December 2015, a retrial was ordered by the appeals chamber. That decision by itself elongated proceedings by 7 years, 1 month and 9 days, as of today. The retrial judgment was delivered on the 30th of June 2021, and the appeals judgment is, we understand, anticipated to be issued in June 2023. As of today, Stanisic has served 2,471 days. And so against that background, on the 13th of June 2023, it will be 20 years to the day since Mr. Stanisic first entered his plea of not guilty to all of the charges. 20 years is a number that should shock the conscience of anyone involved in the administration of justice. His case outlived the ICTY. His son, who will be 25 by the time this appeal judgment is delivered, was a 5-year-old infant at the initial appearance. He has no recollection of his father that is independent of this single criminal case. As Mr. Jordash has already noted, the JCE theory that Stanisic was the right-hand man of Milosevic and the master of all notorious paramilitary units has collapsed fulsomely on 2 separate occasions, leaving one solitary conviction for aiding and abetting in a single municipality, Bosansky Samach. Not for command, but for 2.5 weeks of training and a de minimis act of deploying, again, not under his command. As we argue at paragraphs 193 to 197 of our appeal brief, the consequential crimes on which Stanisic's sentence rests are ill-defined and vague. However, what is plain is that the crimes for which Stanisic was convicted spanned 15 weeks and were geographically confined to a single municipality. Slide 17 shows our estimation, our approximation, taking the trial judgment's findings at their lowest as we must, of the particulars of those crimes. I'm going to leave those on the screen. That you have them at paragraphs 193 to 197 of our appeal brief. In terms of Stanisic's acts and conduct, even taking the trial judgment's findings at their highest, this is a paradigm conviction of remote imputed responsibility. As we know, and as confirmed by the appeals chamber in Alexovsky, at paragraph 182 of their judgment, consideration of the gravity of the conduct of the accused is usually the starting point for consideration of an appropriate sentence. And as paragraph 227 of the Furungiza appeal judgment makes clear, generally the closer a person is to actual participation in the crime, the more serious the nature of his crime. Yet the nature, scope and remoteness of Stanisic's conduct in relation to the crimes was not part of the gravity assessment made by the trial chamber, and this we set out at paragraphs 617 to 621 of our appeal. Moving to the next slide, slide 18 details the features of the conviction that should have been considered, leading to a proper assessment of gravity. Stanisic neither participated in the training nor ordered it. His de jure position within the DB was the sole fact from which his responsibility was inferred. He was found to be aware that crimes would be committed, but was not found to have intended the crimes. It's at paragraph 597 and 606 to 607 of the judgment. He was not in command of the men during the commission of the crimes, paragraphs 388 and 424, and he was not found to have controlled any aspect of the crimes, nor could he have stopped them once they began, since they were under the command of the JNA at that time, 426 of the judgment. We refer your honours to paragraphs 204 to 210 of our appeal brief, which digs into the detail of his participation, which is defined by reference to the overwhelming roles of others, not Stanisic, in that training and deployment. Yet the sentence imposed was one of 12 years. Unsurprisingly, the prosecution appeals against no part of it. As grounds 5 to 8 make clear, errors in the assessment of the gravity of the offence, as well as in the correct application and weighing of mitigation, led to a manifestly excessive sentence. As your honours are no doubt well aware, this is the longest criminal case in the history of the ICTY, which as of today stands at 19 years, 9 months and 11 days since his arrest. That is more than 4 years longer than the nearest Shechel. However, unlike Shechel, none of the delays can be attributed to anything that Stanisic did. By the time Stanisic receives his final judgment, 20 years will have elapsed. As we detail in paragraph 232 of our appeal, whether in custody or not, this process has been destructive of normal life. He was deprived of seeing his elderly parents during their later years. He was deprived of seeing his son grow up. And even when on provisional release, Belgrade was as another prison, attending police station every day, and now he's in custody at the age of 72. And yet, second, not a single piece of mitigation was given for this suffering, and I use the term advisedly. To put a man on trial for a quarter of his life and force him to labour under the risk of a life sentence is no small thing. As recognised by the trial chamber, this was surely an extraordinary circumstance. Not many, except this prosecution, would disagree with that characterisation. But as argued in this ground at paragraphs 227 to 232 of our appeal, instead of weighing this into the sentence, the trial chamber at paragraphs 631 to 632 offered these extraordinary circumstances as the only reason not to weigh it into sentence. Neither the trial chamber nor the prosecution, in responding to our appeal, offered a fair explanation of why that decision was taken. Mr. Stanisic is not asking for mercy, to be clear. He's asking for a fair application of mitigation and of the rule of law. And in truth, this position not to take that retrial order into consideration flatly contradicted the intention of the Security Council in establishing the mechanism, underscoring where it underscored the continuing nature of the accused's rights from the ICTY. Paragraph 4 of UN Security Council Resolution 1966/2010, which created the mechanism's jurisdiction, the Security Council decided that the mechanism shall continue the jurisdiction, rights and obligations and essential functions of the ICTY. Read in context, the transfer of jurisdiction was therefore to be uninterrupted and seamless, including with respect to the accused's minimum guarantees. Restarting the clock on the ICTY's ongoing processes was not what the Security Council intended. It's also patently illogical and unfair. It was a finding made purely on a technicality, without any consideration of the interests of justice. These were the same judges in the same courthouse assessing the same indictment. And this is not a flippant point, because it deprived Stanisic of just mitigation and ultimately his liberty. Turning to ground 5, we submit that the gravity of the offence was wrongly assessed, leading to a manifestly excessive sentence. On a careful analysis, what is absent from the trial chamber's gravity assessment is an assessment of Stanisic's actual conduct. As mentioned, the assessment of the gravity of an individual accused's criminal conduct is a normal starting point when considering the appropriate sentence. The absence of this essential assessment may well explain why the sentences of Stanisic and Simatovic are identical. At its highest, as slide 18, which is still on the screen, demonstrates that Stanisic's responsibility was highly remote and attenuated from the acts and crimes for which he was convicted. Paragraphs 212 to 220 of our appeal and paragraphs 2 to 12 of Annex A to our appeal brief, we submit that the Chamber's selection of these cases rely upon to assess gravity was wrong in principle. It is unclear, for example, why the Chamber relied upon the JCE conviction of Miko Stanisic and Zhuplinin, who were found to have participated in a JCE alongside a number of Serb leaders aimed at the establishment of a Serb state as ethnically pure as possible through the permanent removal of Bosnian Muslims and Bosnian Croats. By contrast, after almost 2 decades of trying to prove that Stanisic was a leading member of a JCE, this has been roundly dismissed, not once but twice. Moreover, as the scope of the prosecution appeal shows, this was not a close-run thing. The Chamber found no contribution to crimes except those reflected in his Bosanski-Samac aiding and abetting conviction. So, all supplies of weapons, finance and logistical support in both the Krajina and SBWS had ceased by the time the JCE had formed, paragraphs 507 and 537 of the judgment. There was no contribution to Arkan and the SDG's crimes in Croatia or Bosnia, paragraph 456. There was no directing and organising the Scorpions, 466. No support to the organisation of the separate Serb government structures in Bosnia. No insufficient evidence, demonstrating that Stanisic directed the formation and support to various Serb forces in Bosnia, and no crimes committed through the acts of purported Serbian state security operatives, paragraph 572. As slide 19 demonstrates, the trial chamber's errors in assessing the starting point based upon the gravity of the offence is plain from careful comparisons with cases that the trial chamber relied upon in their analysis. First, both Miko Stanisic and Zhuplin, and both sentenced to 22 years, were convicted of joint criminal enterprises. Simic, sentenced to 15 years, was also convicted of aiding and abetting. However, he was present during the commission of the crimes in Bosanski Samac and exercised authority over the Bosanski Samac crisis staff. Blagojevic, who was also given 15 years, was convicted of aiding and abetting. However, he was a VRS commander in direct control of military units who persecuted 20 to 30,000 non-Serbs. Lazarevic, a VJ commander, aided and abetted the forced displacement of hundreds of thousands from a vast geographical area, yet he was given just 14 years, only 2 more than Stanisic. The prosecution needs to address these issues and explain, not merely assert, how these cases could offer more than a scintilla of guidance for the starting point for the sentence. Instead, as shown in paragraphs 170 to 176 of their response brief, they ignore them. They offer no explanation, for example, for the incomparably different roles that Simic and Stanisic played. In slide 20, we demonstrate those cases which were in fact closer to Stanisic's levels of culpability, although still, we argue, much, much higher. Dragan Jokic was sentenced to 9 years for aiding and abetting, despite the far more proximate contribution of sending equipment to excavate the burial site used for thousands of victims. Pusic received 10 years, despite having extensive authority over the treatment of Muslim civilians, which were persecuted and abused across 8 municipalities over 2 years. And Panjarevic's conviction was incomparably more serious, and yet this received a sentence of just 1 year more than Stanisic. And again, the prosecution's tactic is to ignore the defence comparisons. They don't want to address these cases, Your Honours. Grounds 6 and 8 concern the remaining submissions on mitigation. Paragraphs 626 to 627 of the judgment, the trial chamber considered mitigation. Once again, the prosecution attempts to avoid the substance of the points raised in our grounds 6 to 8. Paragraphs 154 to 157 of the response, the prosecution asserts that because they were not raised at trial as mitigation, Stanisic has no standing to argue that the trial chamber exercised its discretion wrongly. Of course, Your Honours, this is unsustainable. The prosecution should be non-partisan. In any event, the trial chamber did actually consider these mitigating factors, but just failed to exercise their discretion properly in weighing them. The proposition that this appeals chamber cannot now review them is an odd interpretation indeed of the principles of culpability and the rule of law. Finally, in ground 8, this concerns the trial chamber's failure to take into account the entirety of Stanisic's act and conduct and weigh it appropriately in cooperating with the international community to secure peace and to save lives. The trial chamber concluded that Stanisic did on occasion demonstrate willingness to resolve the conflict, but as our appeal brief shows and as we argue, this was a plainly inadequate reflection of his true role and wholly irreconcilable with undisputed evidence which was on the record. Slide 21 shows that Stanisic was a key peacemaker, not at times, but throughout the conflict, from 1991 until Dayton. This was exemplified, and we can only show you examples at this stage, Your Honour, but this was exemplified by persuading Babbage to sign the Vance Plan in 1992. And we set this out extensively at paragraphs 693 to 699 of our final trial brief, by persuading Mladic to enter into a cessation of shelling at Sarajevo airport. This is at paragraph 24 of the statement of RJS 01, which was at Annex A of the motion to admit that statement, and the sending of a letter to the CIA director in 1995 to find a just and peaceful solution to the Yugoslav crisis, again at paragraph 26 of the same document. As RJS 01 also stated, Stanisic had a wide divide with Milosevic on the question of Kosovo as well, resulting in Stanisic being fired several years later. That's paragraph 25. RJS 11 testified that the objective of the DB from September 1992 onwards in establishing cooperation with other intelligence services was to introduce peace and stability in the Balkans. According to the CIA, Stanisic's DB was a solid service that was successful at dealing with extremism from both the left and the right, and this is confirmed by documentary evidence emanating from the Yugoslav embassy in Washington in 1996. It was also clearly apparent from the unique and highly probative evidence of RJS 01. However, this evidence was a refused admission, Your Honours, and we deal with that in our appeal brief at paragraphs 244 to 255. But for now, suffice to say that the trial chamber found that in denying that evidence, that they would avert any possible prejudice caused by that decision by taking that decision into account in assessing intent and participation in the JCE. However, it is self-evident that they failed to appreciate this evidence was relevant to mitigation and to take it into account in reaching the parsimonious finding which they did, that Stanisic at times demonstrated a willingness to resolve the conflict. Your Honours, I've got about 3 minutes. Thank you. In sum, the trial chamber's approach in reaching that finding and its overall treatment of the clear and consistent body of evidence of Stanisic's acts in furtherance of international peace, cooperation and peace, was erroneous for the following reasons. First, the relevant evidence and analysis showed that Stanisic's extensive efforts to secure peace throughout the conflict, as set out extensively at paragraphs 166 to 177 of our final trial brief, are inconsistent with the inadequate finding that Stanisic worked at times towards peace. Second, mitigation need not be based upon evidence formally admitted into evidence, meaning that the trial chamber was entitled to, and in the absence of any compelling reason not to, was obliged to weigh these factors into consideration into its assessment of mitigation. For example, trial chambers may rely on information such as reports of medical officers concerning health of the accused, and reports from the registry concerning the accused's compliance with provisional release conditions to establish mitigating factors. And the trial chamber did so in this case, for example, at footnotes 2413 and 2414 of the trial judgment. Third, and in any event, the trial chamber erred in not admitting RJS 01's evidence and refused certification for interlocutory appeal. For succinctness, we adopt the reasoning detailed in our interlocutory motion for certification, and that's dated the 3rd of January 2020, which in short sets out why the evidence was unique and therefore required its admission for its probative value, and at the same time was not cumulative of the Rule 76 evidence, known as the stipulations, which was the barrier to its admission. Finally, as noted, if RJS 01's evidence was relevant to intent, it was equally relevant to mitigation. This meant that Stanisic's attempts from 1991 through to 1995 to cooperate with international allies to end the conflict and to save lives through multiple detailed and concrete acts as set out above should have been considered. In any event, the evidence was reliably and multiply corroborated not least by the Rule 76 stipulations and by witnesses such as Sir Ivor Roberts, RGS 11 and RGS 04. This was unchallenged and undisputed evidence, yet none of this highly impressive and probative body of evidence was acknowledged. Your Honours, for all of these reasons, we submit that Mr Stanisic's sentence was disproportionate and impugned by a variety of errors of law and fact and should be quashed. Your Honours, I thank you for your indulgence for the extra time.
Thank you. Any questions from the bench? Well, as we don't have questions for the moment, we will adjourn for a 20-minute break, and after that we will continue with Mr. Simatovic's appeal. Thank you.
All rise, voulez-vous lever?
Okay.